Hi everyone, and welcome to the Art of Estate Planning's monthly Facebook Live. My name is Carrie Payne, presenting on behalf of Tara Lucke. We want to thank so much Timothy Morton for joining us today, who's going to be sharing his excellence, I'm going to call it, Tim, because the topic can only take that to talk about. Tim is joining us from Farage Zini Dunn. He's a director and they practice in family law and estate law in the Australian Capital Territory, New South Wales and Victoria. He has a past life as a tutor at ANU, so he's good at teaching, which I think will serve him well today. And I've sneakily done a search and found out that Tim also had a previous life doing a double major in chemistry with a science degree. So if that doesn't scream nerd, Tim, I don't know what does.
Probably my board game collection, Carrie.
But I think it means that you're the best person to be giving this presentation because you're a nerd and you can teach. So this topic is the topic for those two talents. So this topic, I think, has come about because so many of our practitioners have, wanted to know more about this because it is something that is so hard to understand at a practical level. I think it's even hard at an academic level, to be honest, as well. But certainly applying it on a day-to-day basis in our practice is so complex. So thank you, Tim, for sharing your time with us. I will let you take the floor, and if any questions pop up, I'll jump in and ask you. Okay.
Wonderful. Okay. Well, look, thanks first for having me. It's an enjoyable topic, one I've been lucky enough to talk about before. So I've expanded on my previous iterations, and hopefully this is helpful for everybody. Starting from the horse's mouth, so to speak, the original case of Saunders and Vautier. Vautier in this case was a nephew of the deceased person, and he was left £2,000 of East India Company stock, which I think in today's terms is about $500,000, so maybe a bit more. The will says Vautier gets the capital at age 25, and until 25 he receives the income. He turned 21, which at the time was the age of majority, and he demanded the gift. Vautier in this instance was successful, hence we're here today. Lord Langdale, Master of the Rolls, held, I think, that the principle has been repeatedly acted upon, and where a legacy is directed to accumulate for a certain period, where the payment is postponed, the legatee, if he has absolute indefeasible interest in the legacy, is not bound to wait to the expiration of that period, but may require payment the moment he is competent to give a valid discharge. It's classically old language, familiar to those of us who think of Banks and Goodfellow as well, not too far removed from that. It's been adopted in Australia expressly in CPT Custodian Proprietary Limited, a High Court case in 2005, where the court quoted Thomas on Powers saying, under the rule in Saunders and Vautier, an adult beneficiary or a number of adult beneficiaries acting together who has, or between them have, an absolute vested and indefeasible interest in the capital and income of property may at any time require the transfer of the property to him or them and may terminate any accumulation. In some respects, calling it a rule arising from Saunders and Vautier is a bit misleading because it really applies from first principles. You've created an absolute indefeasible interest in a particular person who can give a discharge. It can't go anywhere else. So the trust has vested and the trustee really has no role. You're just removing a trustee that is a trustee of nothing at that point. So the key elements you're looking for are a trust. You're looking for adult beneficiaries, we're said to be sui juris, all of whom consent. The interest is in income and capital. Of course, you can't have this rule applying in circumstances where you've got a life estate, for example, in favour of a spouse followed by remaindermen who are entitled to the capital in the future. In that instance, the interest in income and capital are not vesting in the same individual. The interest is vested and not contingent. So there's no conditions to be met in order for the gift to pass to that named beneficiary. The rule I've found can apply unexpectedly, and it's expressly intended to undermine testamentary intent. So gives you something at least to hose down those clients who say, but this is not what the will wanted, it's not what they were supposed to do. It's what the law is actually trying to do. They're trying to reduce the term of trusts if they can in any circumstances. So let's talk about vested or contingent. One of those terms, again, that takes you right back to law school. It's come up a little bit more recently in a few cases that have talked about, and I can't bring those cases to mind, but Carrie, I'm sure you've talked about it, the cases that talk about when you've got a residuary beneficiary attaining a vested interest, whether that means that if they were to die before residue being determined, do they get their gift or not? Those cases come in here as well. That's partly the question of, is it vested or contingent? It's vested if the beneficial interest has passed to the beneficiary. That is, they are equitably but not legally entitled to that property. It can be vested if enjoyment is merely delayed. So you can ask the question, what happens if the beneficiary dies? On a proper construction of that clause in the will or in the deed potentially, because this doesn't just apply to wills, of course. What would happen if that beneficiary dies? It may be contingent if age is a condition of that gift. Specifically, if in order to benefit from that gift, they must attain that particular age, and if they don't, then no gift passes. You might take, for example, a gift just like in Saunders and Vautier, perhaps to a nephew, but where it's contingent on that beneficiary attaining the age of 25. And if they don't, then the gift goes into residue. Then the residuary beneficiaries are entitled. So it's a contingent gift. He hasn't met the condition. He's not entitled until he does. You're going to need clear evidence, though, that it is contingent, because the courts, as I've said at the end there, will favour early vesting if they can. All that said, even if it is contingent, all the contingent beneficiaries can consent, because you go back to the current restatement of the rule, an adult beneficiary or a number of adult beneficiaries acting together who has or between them have an absolute vested and indefeasible interest. So if you drag them all together and they're all on the same page, you can potentially apply the rule in Saunders and Vautier. So why does it exist? In Jacob's Law of Trusts, or at least that citation is correct when I last checked it. I probably should have checked my newer edition. It's been said that the principle upon which the rule is based is that any restriction on the enjoyment of a beneficiary who is sui juris of a vested interest is inconsistent with the nature of that interest and must be disregarded. This person is entitled to that property now. Any term of the will or deed that's inconsistent with giving that beneficiary control over that property is necessarily or needs to be necessarily disregarded. And as it says here, thus understood, the principle often will involve the denial of the intentions of the settlor or the testator. So you've got a conflict here between the nature of the interest and the attempt to delay that interest. Delay is inconvenient, creates disputes. The courts don't want that. So let's look at what I think is one of my favourite recent examples, because it captures the application of the rule very well. So Christic and State Trustees, 2012 case from Victoria. The deceased in this instance died in 2007, leaving two sons. Mark 24, Nick 20, when the hearing took place. The will contained those gifts. So I give the sum of 20 grand to each of my sons, Mark and Nicholas, as survived me and attained the age of 21, severally and absolutely. And then reading that together with the following clause, you can sort of see that what he was trying to do is give them a bit of a start and then go on to delay the residue until they were old enough to manage it. So the residue goes on to say, I give the residue of my estate to such of my said sons, Mark and Nicholas, as survived me and attained the age of 40 and 36, respectively and absolutely. And then conditions about if they predecease or fail to obtain a vested interest, leaving a child or children, etc. They both survived the deceased by 30 days, and the residue was worth $450,000. So obviously, large sum of money for kids of this age or anyone, but not a lot to be arguing about in court. Counsel for Mark and Nick in this instance argued that no grandchildren had survived the deceased, that the gift over could therefore never take effect. Relevantly here, it says, leaving a child or children who survived me. So the substitutional gift to grandchildren in this instance required that those children survive the deceased. No grandchildren existed at the date of death, so they would have to be born after the date of death and can't therefore have been said to survive him. That's a matter of construction of the terms of this particular will. So if Mark or Nick had died before 21 or 40, 36 respectively, the gift would form part of their estate. That's what the counsel, Mark and Nick were arguing. If both had died, the provisions of intestacy in Victoria would apply and the same result would occur. That is, Mark or Nick would equally share their father's estate, just on intestacy, not via a will. So the only people who could ever benefit from the estate were Mark and Nick, under any circumstance. Macmillan, Justice Macmillan, as she then was, characterised the rule as follows. The rule in Saunders and Vautier operates to override a testator's intention to prevent the beneficiaries from taking their shares until attaining an age beyond majority. The rule has no operation unless all the persons who have any present or contingent interest in the property are ascertained sui juris and consent. So we know who they are, they're all over 18 and they all agree. In those circumstances, the beneficiaries may put an end to the trust by directing the trustee to transfer the interest in the estate to themselves, notwithstanding any direction to the contrary in the trust instrument. Her Honour further held that because Mark and Nicholas were the only persons who between them have an interest in the residuary estate, are sui juris and consent, in her view, they can require the transfer of the residuary estate to them by reason of the application of that rule. It's a rather neat example of the application of the rule.
Timothy, can I just ask here, and again, I'm asking on behalf of what I know is a large horde, let's call them, of estate planning practitioners. So the result, you believe, based on this judgment, would have been different if there were grandchildren present? So there were children of Mark and Nick? If
they had survived the deceased in a relevant sense, yeah.
So it's irrelevant if they go on to have children of their own because it's after the date of death of the deceased.
In the construction of this will, in this instance, yes.
Yes. Okay.
But that's an apt question because it's about to come up.
Ah, good. Because even, one of the strategies we think about sometimes is making that gift over rule apply so that, that person, if they were to have children, it would go down to them trying to defeat that rule. But those people then actually have to be present is the idea based on this rule.
That's right.
You're about to crack open something else with another case?
Well, that's right. Yeah, so I'll go to, that's exactly the question that I've asked at the end. The critical elements were Mark and Nick were the only people who could ever benefit. They both consented, were both sui juris. But what would happen if the gift over was effective and the children were possible? Enter Anna and Kiss. Get cited for other reasons as well. Gerdia Lydia Kiss died at age 90, survived in that case by Andrew, her son, and her grandchildren. Ages are listed there, 26, 24, 22, 19. So everyone, sui juris. Framed as an application initially for judicial advice, it then continued as a construction application. Read as follows. My trustee shall hold the rest and residue of my estate as follows. To divide it equally among my grandchildren, Daniel, Karen, Benjamin, and Brenton, who survived me and attained the age of 45. Then, by way of clarification, each grandchild shall take this gift as they reach their 45th birthday and need not wait for the remaining grandchildren to attain their 45th birthday. The plaintiffs in this instance argued that there was no gift over clause in the will. The court would ordinarily construe a will so as to avoid an intestacy. Therefore, you should construe it to have given an absolute interest rather than creating a potential intestacy. The income, and that goes back to Isaacs in Fell and Fell. The income was not disposed of in the will, meaning it passes with the capital of the trust, and there's a power of advancement. Defendants said it's not vested because the gifting clause 4 is a class gift and no interest passes until a member of the class can be identified. In this instance, such of them that survive and attain the age of 45. That's your class gift, right? Survive me and attain the age of 45. So you've got a class that's limited to those 4 people, but they also need to attain the age of 25. The gift was contingent, and that's reinforced by the words by way of clarification. You're only clarifying it because there is a circumstance where some may attain the age of 45 earlier than others, and they should take their gift when they attain it because it's a condition that they attain that age. That's at that point their interest is absolute. Justice Hallen held that the gift is not to the named grandchildren, but the named grandchildren who attain the age of 45 years. Therefore, there's no person in whom the residuary estate is vested. The residuary beneficiaries presently are unable to terminate the trust in the will, and the plaintiffs are not entitled to do so at their behest. The critical elements here was intestacy was possible and would benefit the son. No member of the class was identified, and expression of a contingency was clear. There is a presumption of early vesting referred to expressly by Justice Hallen at paragraphs 41 and 42. I haven't extracted those here, though. So it's an example of where the other beneficiaries of residue in the event of an intestacy may not consent, they didn't consent in this instance, and as a result, no member of the class could be identified. So there's no vested interest to claim out of this. I can't remember how I came across this case, old case, but instructive as well. An ACT decision. Betty Jean Lee died, survived by her son Rodney. Betty wanted to rule from the grave. She directed here that her residence Rosehill will be retained for 10 years. At the expiration of the 10 years, the residence shall pass to my said son absolutely, provided he's living, in the event of him not surviving for a period of such period as to 1/2 share for his wife Vicky, and the other 1/2 share to the children of the marriage, living at that date in equal shares, tenants in common, and if there are no children of said marriage, then such 1/2 share passes to Vicky. And drafting has come a long way. As the rest and residue of my estate, my son, provided he survives me for 30 days, shall be entitled to net income for a period of 10 years, and at that time the capital shall pass to him. And in the event of him failing to survive either period, the provisions of the beneficiaries in clause 6 shall apply, and in the event of the failure of any of the foregoing provisions, then to the North Rocks Deaf and Blind Society for Children. Rodney didn't want to wait, he wanted to bust the trust. Miles J in this instance held, it appears to me that the better view is the rule may be avoided either by the creation of an intervening discretionary trust or by provision of a gift over in the event of a contingency taking place. Such contingency may include the death of the donee or the legatee. If clause 4 of the will stood on its own, I should have little hesitation in ruling that the beneficiary was immediately entitled to the whole of the testator's interest in the residence Rosehill. Similarly, if clause 7 made no provision for the residue to pass to surviving children and grandchildren as yet unborn, if any, in the event of the son failing to survive for 10 years, then the son would be immediately entitled to the residue. So looking at 4 and 7 again, 4 went on beyond that, but just said just be retained. If that was all it said, then fine, it's a vested interest in residue, it passes with residue. Equally, if we didn't have all those backup and contingency clauses, 6 and 8 there, he wouldn't have had a problem finding a vested interest in Rodney. As it is, he couldn't. I think the will as a whole confers a contingent interest on the charitable organisation named at clause 8. So you've got a backup gift to charity, which, spoiler, I think is probably the most effective way of avoiding any application of the rule in Saunders and Vautier, because with a good cypre clause, you're going to be in the position that there's no risk of a contingent interest not arising in some position. And so you can't have a adult beneficiary bust the trust early. Relevantly and in obiter, his honour discussed unborn children. There's no evidence as to the age of the second defendant, but apparently it is uncontested that she is not yet beyond childbearing age. Whilst there is no power on the court to appoint someone to represent a class consisting of solely unborn children, I do not think that their contingent interest can be disregarded. Which goes back to your point, Carrie. What if the children are possible? What do you do about that? I've added the FLR citation in this clause. I think I've duplicated the clause unnecessarily. This is relevant in Falkenhagen, where an application was made to end a trust created by deed in 1969. Trust provides accommodation to the plaintiff by way of a life estate and other rights that come with that. The plaintiff was 77 when the proceedings were commenced, and his wife was 72, and they had no children. The two options were put before the court in this instance. The first, that we wanted to end the trust with the application of the rule in Saunders and Vautier, and the second, to make a partial administration order under the New South Wales UCPRs. Justice Lindsay extracted in his judgment that the plaintiff has disclaimed any intention to have or adopt a child or ever remarry. Any possibility that the plaintiff will ever, in fact, have a child or remarry is remote. All persons presently known to have an interest in the trust seek to have the trust terminated and the trust property conveyed to the plaintiff absolutely. Any possibility that another beneficiary will materialise is so remote as a matter of practical certainty that it can be disregarded. However, the defendant is trustee of the trust. In this case, the defendant doesn't stand in the way of the beneficiaries, and this is perpetual trustee company, provided that it can be achieved as a matter consistent with principle and they're protected from any liability. Ultimately, Justice Lindsay held that the rule in Saunders and Vautier could not apply because there could be a future wife and there could be future children, whether they be natural or adopted. These are possibilities and it couldn't be ruled out, but they were contingent beneficiaries. So you couldn't therefore have everyone represented before the court and consenting. One of the more recent cases I could find.
Sorry, Tim, just to jump in. So I think that sort of answers my question about what we talked about before, that even if there aren't any grandchildren alive at the relevant time, the fact that there could be is enough to kind of defeat that rule, so to speak. The key thing being what I think you said before, I can't remember what you called it, but, it's all about the contingency, right?
Is there a contingent interest somewhere?
Yeah, even if they're not necessarily here at the time. So thank you. Sorry to interrupt, Tim. I'm just making sure that we reiterate for people that aren't good with listening to the detail but want to hear the big stuff. So
not at all. That's fine. It's worth emphasising then, before I move on again from this one, that the orders were ultimately made, just not under Saunders and Vautier. It was made as a partial administration order on the basis that the plaintiff, the son, would undertake to pay money back if a beneficiary later came knocking.
Okay.
So there are other causes here. Saunders and Vautier is arguably just one of the tools in the toolbox for the same outcome. But the other options will require different tests.
Interesting. Yeah.
Here. But bearing in mind, everyone was consenting here. So everyone who currently may have had an interest consented to this course. Despite that, because of their potential other beneficiaries in the future, his honour could not make the orders sought under Saunders and Vautier, but could make the orders ultimately. Batten and Salir is interesting. It's a culmination of a bit of litigation. First, an application about validity of an informal will, citation provided, a construction suit. The language of the will was quite difficult to comprehend, but it was clearly put at the extract below, followed by the vesting application, which was made last year. Justice Lindsay again set out the result of the construction suit at paragraph 5, where he says the gift effectively said, the property at 19 of 8 Allen Street, Waterloo, is to be held by the first defendant upon trust for the fourth defendant. In this case, Mr. Batten was the fourth defendant, until the fourth defendant turns 25. Note that language there, until, at which time the property is to be transferred to him. The income derived from the property is to be accumulated until the fourth defendant turns 18, at which time the amount accumulated and future income is to be paid to the fourth defendant as and when it is earned. So you have an interest in income, and you have a arguably delayed interest in the capital. At this point, though, no one was there to argue the point. Everyone else entered submitting appearances. So Lindsay J continued. First defendant and second defendant have both filed submitting appearances. The plaintiff's claims for relief are not opposed. And in support of the plaintiff's primary claim for relief, the following features of the case are noted. The plaintiff ceased to be under any form of disability when he attained his majority at 18. Under the will, having attained his majority, he's absolutely entitled to all of the income, including accrued income on the property. Although the will is expressed to defer the plaintiff's full enjoyment of the property until he attains the age of 25, his entitlement to the property is not expressed to be conditional on the attainment of that age. Remember, it says to be held on trust until the fourth defendant turns 25. It doesn't say on the condition. There's no words there that say he must, in order to take the benefit of the capital, attain the age of 25. It simply says it's held on trust until 25. In my opinion, Justice Lindsay says, the plaintiff is entitled to relief of the nature sought in his primary claim for relief, because on a proper construction of the deceased's will, he has an absolute vested and indefeasible interest in both the capital and the income of the trust held for his benefit. So he got his assets. He got the capital of the trust paid out. So here I've just to collect together some reflections on these cases. I think you've got to start with a pretty deep consideration on the actual and the correct construction of the will, bearing in mind at all times that it's the court's job to construe wills. It's not our job as solicitors to construe wills, but you can give advice, can't you? So give deep consideration of who's actually entitled to the estate. You need to consider not just the testate succession, but the intestate succession. Can't just ignore unborn beneficiaries just because it's inconvenient. Effective gifts over can prevent the application of the rule. They've got to be properly drafted. There is a presumption in favour of early vesting. The rules is expressly intended to undermine the intention to delay vesting. And the facts of each case, as always, are critical. So I have some practical implications and some examples I wanted to work through after that. Bear in mind that if you've got a vested indefeasible interest that's just delayed until they're attaining the age of 18, then it is an asset of that minor beneficiary. I had a will, for example, that said I give my whole estate to my dear son. Son at the time, I think, was 9, something like that. There was no word of limitation saying it only vests at age 18. I just give it all to him. Under those circumstances, it would be held on trust for him until he attains the age of 18, at which point it's all his. But importantly, it's a vested interest in him and his estate. So if he were to have died, then his mum would have got it all. And his mum at the time was not involved in the child's life. The child was in the care of the maternal grandparents, and she was on trial for pretty horrific murder. So we didn't want it to go to her. Certain advice, of course, was provided, and the late, great Richard Williams acted on the statutory will application, and the application was successful. Point being, identifying that you've got a vested interest in a minor has implications not just in relation to a Saunders and Vautier application, but to other applications you might make that are well outside of the scope of the talk, but worth flagging as something you might want to consider as well. Don't be solely focused on Saunders and Vautier in this instance. If intestate distributions, of course, are seldom appropriate.
Tim, just to check there, because that's a horrific result if that is the case, if the minor passes away and then that forms part of their estate. If there's a clause after that says if the person passes away or doesn't get to that, the gift fails because they don't get to 18, would that change that outcome?
Absolutely. Yeah.
Great. Yeah.
We've got a very specific example here, right? We've got to give everything to my dear son. One liner, that's it.
I wonder if he wasn't a dear son. That would change the outcome.
That's right. Got to watch out for those antelope sons.
That's right. So definitely picking out the favourite child by using the phrase dear. But that's really great to hear, because it's something that, again, when you see that, you think nightmare. And when you see especially those wills that are made, those DIY wills where they write from the post office, everything to my child, and as you said, if they're separated from their partner and the kid passes away before they get to 18, I don't think they appreciate what that actually means. So it's really important that we think about that contingency for after, underneath that as well.
Absolutely. So here I just put together some simple examples. One's a simple example, one's, I think, a little bit more complicated. So Jack and Jill in this instance have a child, Annie. Jack and Jill are separated. Annie's got nothing to do with Jack. Jill's sister Sally helps out with Annie's care. Jill dies. Annie and Sally both survive by 30 days. Residue of 800 grand. And the will says, I give the residue of my estate to my dear daughter. I kind of used in that previous example as an inspiration here. My dear daughter Annie, when she attains the age of 25, provided she survives me. But if she dies before me, then to give it to my sister Sally Smith. There are no interpretive clauses in the will. That's everything. Your immediate issues are the language when she attains the age of 25. I give when, and then the condition provided she survives me. But if she dies before me, then to give it to Sally. So under these circumstances, you've got an absolute gift to Annie, delayed until the age of 25, on the condition that she survives, and on the facts she has survived. That's happened. So the survival in this instance is the contingency that gives the benefit. The enjoyment of the benefit's merely delayed. There's no backup beneficiary, so you can't interpret that clause to say Sally benefits at some point in the future, because all Annie needs to do is attain the age of 25. Survive by 30 days, I mean to say. She's done so, and then her benefit is simply delayed until 25. The intestate beneficiary in this instance would be Annie. And if Annie died, it will form part of her estate. So therefore, the only intestate beneficiary is estranged father Jack. So same examples I gave before with a bit more meat on the bones. Also a more believable clause with a bit of careless drafting perhaps, or a will prepared with a will kit. You could see that language turning up very easily. And you've immediately got both a Saunders and Vautier issue, and you've got an intestacy issue and a statutory will issue as well. So in that example, Annie can clearly bust the trust at 18. She needs a will. She can't make a will. Statutory will is an option. Further example, though, a larger family in this instance. This is adopted from a matter that arose between the time of being asked to do this and now. So this is a live example. Quite coincidentally, I've got Agnes Gregory dying, leaving two sons, 49 and 46. One son has two daughters, Mary and Madeline. The will provides, after a bunch of those standard beginning clauses, to hold the balance remaining upon the following trusts: my son Daniel, Frederick, and my granddaughter Mary and my granddaughter Madeline, who survived me and reached the age of 25, in equal shares. Should any of the beneficiaries predeceased, their share is to be equally divided between the surviving beneficiaries. There's no other backup gifts of residue, no substitutional gifts. There's nothing in there that says if a child or grandchild dies before me, then their children take their parents' share. Arguably, the statutory substitution provision wouldn't apply because there's an express accrual clause in there. You've already got it's divided between those children, the children and the grandchildren who survive and reach the age of 25 in equal shares. And you've got a backup only in the instance that a beneficiary predeceases, but it just gets added equally to everybody else. So I would argue that the statutory substitutional provision would not apply in this instance. So there are no other beneficiaries. This is it. There is a power of advancement to apply, as you've seen before in many wills, for the maintenance of education, advancement, or benefit of a beneficiary, the whole or any part of the capital or income that they may be entitled, and accept the receipt of that payee as an absolute discharge. The question here the issue here is none of the family members, none of the beneficiaries, and least of all Mary and Madeline, want that trust continuing until they're 25. Does the rule apply? Well, on the facts as you've got here, Madeline's under the age of 18, so she can't consent. But once she's 18, and if everyone agrees, the only potential beneficiaries are Daniel, Frederick, Mary, Madeline. They're the only people that can get it. Arguably, the power of advancement doesn't go far enough to allow a payment to a parent of a child who's under the age of 18, so we probably can't use that for Madeline being under the age of 18. But once they're all over the age of 18, it seems to me that just like in Kirkhagen, you've got two options here. You can probably use the power of advancement, but then you're sort of still a trustee and you've got to think about what obligations might sit on you. Or you can just get the beneficiaries to just bust the trust, say, let's vest it, it's done. So at first blush, it seems to me that you could overlook this as a matter where the rule in Saunders and Vautier might apply. But looking at it more closely, I'd argue that once they're all over the age of 18, they've all survived. Yes, fine, it's probably a condition that they reach the age of 25. That goes back to all the adults who have a contingent interest in the estate consenting. The only other people who could get a benefit are Daniel and Frederick and this other surviving grandchild. So if they all consent and they're all happy to go ahead with it, then it seems to me that the rule in Saunders and Vautier neatly applies here, provided everyone continues to agree and when Madeline's the age of 18. So it can, as I said before, it can pop up in unlikely circumstances, and even where you might not necessarily think it does at first instance. But when it does, it's a useful tool to have in your toolbox. So practice tips. Ask yourself, is the same person or class of persons entitled to the capital and income? Is the gift vested, or is it somehow contingent? If it is contingent, what are those contingencies? Is it simply that they survive? If so, maybe they've met the contingency already. Is it attaining a particular age a contingency? If so, are there backup beneficiaries? Who might be the beneficiaries on intestacy? If the gift appears to be vested, are there other words in the will that could be said to express some kind of contrary intention? Bearing in mind that the court is going to favour early vesting if it can find it. Is a justifiable argument, then maybe it's worth running that. And then who would benefit on intestacy? Is it the children? Is it grandchildren? Is there a gift over clause, a substitutional gift that applies specifically, not just if the beneficiary dies before the deceased, but if they die before attaining a particular age or other contingency? It's really a matter of construction of the document, whether it be a will or a trust deed. What does the will actually say? What obligations does it place on the trustee? And what conditions are actually there? So look closely at the document, consider a construction application if necessary, but in some instances you may not need it. So thanks for your time. You can reach out, ask questions on Messenger or by mobile. I'm very happy to take those calls. I like working through interesting questions. Hence, I like to always also contribute on the Art of Estate Planning. So whack your questions up there, and I'll do my best to reply as well.
Thank you, Timothy. I know we've had some technical difficulties today with people being able to join us live. So this will be pre-recorded for people to listen to later. So to the extent that you do have any questions for Timothy, please feel free to contact him directly at his law firm. Or if you wish to come through us, email them to hello@theartof-estate-planning.com.au. Tim, I know that you said, and I think, we've the fact that you said you like the interesting question and that something was your favourite example of a case, I'm just going to come back to that double major in chemistry. I think this is a really great topic in many ways because, as I said at the start, it has a really academic background, but as you've sort of just shown, there's some really practical outcomes. Do you have, we definitely in the Art of Estate Planning have our own clauses. We have obviously Tara's Precedents that she sells, and we also have a clause library as a part of that that has clauses themselves. Would you be happy to share what you thought was something that would defeat that rule if you were giving a gift to a minor? And that way we can make sure that we're all singing the same tune about how that works. So I'm confident that Tara's Precedent already does that, but certainly two heads are always better than one. And I think that given what you've just shown, how wrong it can go, we want to make sure that, not only do the testator's wishes come to pass, but they come to pass in such a way that not everybody's been traumatised through the process, whether it be through, negotiations or going to court. If we were to take away, one thing away from today, what do you think would be the thing that you thought, this is the thing I want you to hear from me?
I think it's having, if nothing else, having contingent or backup gifts over that are effective. Make it clear that beneficiary A gets it if they attain the age of 25 or 18 or whatever. But if they don't, then it's beneficiary. And if it's not that beneficiary, then maybe a charity. Think about having backup charitable gifts, and don't be afraid to ask the question, particularly of young couples. It's always horrible to say, what if your kids die before you? Because no one wants to contemplate that as a possibility. But the way I like to put it is, what would you want to do if you just happened to live an exceptionally long time, lost capacity, and you outlived everybody? Much more gentle, right? And I dealt with a matter not dissimilar to that in the estate of McMullen, a ACT case, where the deceased had left a long list of gifts, but all those beneficiaries had died before her, and she just lived for a very long time. And the backup gift said, and these named people shall receive nothing from the distribution of my estate. Some of those people were beneficiaries on intestacy. It also said that the house shouldn't be used or sold for use as a brothel, which I thought was fun. It was ultimately construed that those beneficiaries on intestacy still benefited, but that's another argument for having a backup gift. And just to come back to the original question, but it's really about having effective backup gifts. What happens if everything's added to the pot of one surviving spouse? Where should it go then? Should it go equally between the families? Should it go disproportionately between the families? Do we not like some siblings? Do we like others? Do we like nibblings more than siblings? Or do we want to just look at charitable gifts?
I think it's a very valid point, Tim, because it is an awkward conversation and something a lot of people don't think of when you get them into the room for an estate plan, because they're pretty clear it's each other and the kids in various different structures if we're using testamentary trusts. But quite often we kind of get the blank stare, like about, oh, we didn't think about that. And I think there's ways, as you said, that you can have that discussion a bit more lighthearted about, I usually make the joke, well, you're correct. You'll be 6 foot in the ground. You probably don't care. But, do you care enough that that brother who you don't like will probably get it on intestacy? Yeah. So if you really don't like him, give it to a charity at the very bottom line, or, give it to someone else, and talking them through examples of what they can do to make them feel, or to give them permission to think about options. Like I sometimes say, normally we see a 50-50 division between the families, or, division across all the siblings regardless of how many are on each side, or we just see nieces and nephews, we see friends, we see charities. So, and just reminding them of that, that those rules of intestacy exist, and do they like the people that are next on the list, so to speak, under intestacy enough to get it? And not just to mention, even if they do like them enough, do you want to wish them having to go through the process of dealing with the gross parts of an intestacy? Why wouldn't you just make it clear in your will?
100%. Totally agree. And charitable gifts can't fail, particularly if you've got good sapere clauses in the will. Yep. You're always going to have a beneficiary. So you don't have any risk of no contingent beneficiaries, and no situation where, like in Christic, you're looking at the intestate beneficiaries, they're the same people. Okay, they get it. Yeah.
Tim, thank you so much for your time today. I really do appreciate it. And I appreciate we finishing up a little bit early, given we've not had the stream of questions firing through. So just to remind everybody, Tim is contactable through his firm. He is a member of the Art of Estate Planning Facebook page. Try not to harass him too much if you can. His time is valuable. We appreciate your time, Tim. And, to the extent that you want any specific advice, Tim is a practicing solicitor, so you can reach out to him. And again, if it's something that you want to sort of stay anonymous with and want us to reach out to Tim on your behalf, please feel free to email us. Thank you again, Tim, for your time. We really appreciate it, and looking forward to seeing where you take things next.
Pleasure. Thank you for having me.
Wow, wasn't that a fabulous training by Timothy and Carrie? So if you don't know me, I am Tara Lucke, founder of the Art of Estate Planning, and I just wanted to share a couple of insights and thoughts that I had while I was watching the training, particularly about testamentary trusts. So if you are familiar with my work, you will know that I am a testamentary trust super fan, especially for young couples with minor children. One thing that I think we can sometimes overlook when it comes to drafting for this demographic is the impact of Saunders and Vautier. So, if it wasn't entirely clear, Saunders and Vautier does not apply to gifts in testamentary trusts. So this can actually have a huge impact on preserving an inheritance and continuing a trust for minor beneficiaries. And so I wanted to walk you through a little example. So let's have a look at our couple here. We've got Dan and Elsa. They are young. They've got 3 minor children. And let's look at what it might look like if they came in to do their estate planning. So let's say they've got the simple or the I love you will, where Elsa dies, she leaves everything to Dan. If Dan dies, their intention is for everything to be split 3 ways between their minor children, and they want Elsa's sister Anna to be the trustee. So even though this is not an official testamentary discretionary trust will, we still technically do have a bare trust in the will. And it's a fixed bare trust where there's a third of the estate set aside for each of these 3 children. And Elsa's sister Anna is going to be the trustee of each of those 3 trusts. So we could either have like a 3 trusts or 1 trust. But we've basically got a bare or fixed trust pursuant to the terms of the simple will, right? So let's have a look about if Dan and Elsa both died, how does Saunders and Vautier apply? So under the simple will, once those children reach 18, they can rely on Saunders and Vautier to call for their trust to be vested and enforce their absolute entitlement. And in that case, Anna really cannot do anything to protect those 18-year-old children once they each come of age from spending their inheritance however they like, right? She's really not in any kind of position to protect them legally. All she can do is provide moral guidance and direction. If instead of the simple will, Dan and Elsa had used a testamentary trust will, so they'd put everything into either a single testamentary trust for all of the children to share or a testamentary trust for each child, the rule in Saunders and Vautier would not apply because we do not have each of those children becoming absolutely entitled to their share of the trust property once they turn 18. If we set it up as a proper testamentary discretionary trust, then we actually have a whole range of beneficiaries who could potentially be entitled at the discretion of the trustee. So Saunders and Vautier just does not apply. The trust can continue after the children turn 18, and the children cannot call for their trust to be vested. And so, in that sense, Dan and Elsa are setting children up in a structure where they can appoint people as trustees, like their trusted sister Anna or other family members or friends, to manage that trust until the controllers decide to hand over the control of the trust to the children, or decide to release capital as loans or lump sums, or decide to vest the trust. So, from my perspective, I think it is really important to emphasize that if you have a client sitting in front of you and they're saying, "Oh, I want the children to not get their money until they're 25," well, a simple will is not going to guarantee that. The only way to guarantee it is the testamentary trust will. And I do sometimes think we gloss over that when we're explaining the difference between a simple will and a testamentary trust will to a client. Only way to give them certainty that the children won't get their hands on that money when they turn 18 is the testamentary trust will. So I just really wanted to emphasize that because, as you know, I think testamentary trusts are incredibly powerful, and this is another area where their power is highlighted. So I wanted to just make that super clear. If you've got any questions or feedback for Timothy, Carrie, or myself, please reach out.